Hey everybody, I don't know about you, but as you've watched out over the world, the war in Russia and Ukraine is not just isolated to Eastern Europe. It's spread all over the world, and you can see it in market instabilities. You can see it here. People who do not think that that war is affecting you, all you got to do is look at gas prices. You look at your food prices. You see the global change that has happened. But you know something that's also affected investments as well. And I've said all along, legacy precious metals is your navigator. They're the ones that see you through to get to the next level. The good news about this is, even with market volatility, market instability, you've got options. And gold prices are rising as investors turn to gold. And gold presents a hedge against this inflation and that protects you against the weakening dollar, which we are seeing. Legacy Precious Metals is the only company I trust to deal with gold and silver and the other precious metals. You need this investment. You need this as part of your portfolio to keep you buffered from what we're seeing in the world, war and volatility in the market. This is where you need to be. Call Legacy Precious Metals today. Be proactive about this. Get on board with it. Call them at 866-528-1903, 866-528-1903, or you can download their free investor's guide at legacypminvestments.com. legacypminvestments.com, your navigator in a volatile world of investments.
Do you want to listen to a podcast?
By who?
Georgia GOP Congressman Doug Collins.
How is it?
The greatest thing I have ever heard in my whole life.
I could not believe my ears.
In this house, wherever the rules are disregarded, chaos and mob rule. It has been said today, where is bravery? I'll tell you where bravery is found and courage is found. It's found in this minority who has lived through the last year of nothing but rules being broken, people being put down, questions not being answered, and this majority say, be damned with anything else. We're going to impeach and do whatever we want to do. Why? Because we won an election. I guarantee you, one day you'll be back in the minority and it ain't gonna be that fun.
Hey everybody, it's Doug Collins. Welcome back to the Doug Collins Podcast. I want to just say as we start off, thanks for listening to the Doug Collins Podcast. There's also a special thing going on right now, a special event, special promotion, however you want to put it, that if you want to come sit down, maybe you want to be a part of our podcast, then you have the chance to do that. Go to the DougCollinsPodcast.com, the DougCollinsPodcast.com, and you can enter to win a trip to come see me here in Georgia. Spend some time with us, have an actual taping of the episode, and it's our Terrific Talkers weekend. You can put in by going to my website, the DougCollinsPodcast.com, and you can enter to win that trip, 3-day trip. Would love to have you, love to meet with you. We've got a lot of great listeners out there and want you to be a part of that. So go and check us out at the DougCollinsPodcast.com, and you'll find links there so that you can enter to come and visit with me here in Georgia, spend some time, and actually attend a taping of the Doug Collins podcast. Want you to be a part of that. Also, I want you to know that your help in sharing this podcast, liking it, downloading it, subscribing it, it also very much help us as we get the message out about what's going on in our world. You'll see the interviews, you'll hear my commentaries, and you'll be a part every day when you subscribe and download the Doug Collins Podcast on whatever platform that you get your podcast from. Also explore the DougCollinsPodcast.com website. We've got blog posts. We've got other things on there that you can get a lot of information from. We want to just share that with you. And I want to say thank you for being a part of the Doug Collins Podcast. Now, over the past little bit, last few weeks, is one of those times when you get to the end of June, for those of us who are lawyers, for those of us who are involved in politics, you know that the month of June, some years is quieter than others, but other years it is just it is jam-packed with really earth-shaking news. Where does it come out of? It doesn't come out of Congress typically. You're not getting a lot out of Congress in the month of June. What you are getting a lot out of is the Supreme Court handing down rulings in the cases that they've been hearing all year. As a reminder to everyone, the Supreme Court starts hearing cases. They've heard less and less over the years, but they hear cases starting in October, and they typically will hear those cases through April. And then they will begin the process during this time of decisions and writing opinions and how they will formulate what they believe the outcome should come in this case. Now, some of the smaller cases, they'll announce the decisions, as early as, February, March, maybe some of the early decisions in April, May. But as you get closer to, it's almost like in sports, as closer you get to the playoffs, the more intense the decisions are. And if you get into the end of the Super Bowl, the World Series, or wherever you may be, those are the games that matter most. These are the championships decided. So as an analogy, for Supreme Court rulings, the ones that are decided in June, when you get those rulings, those are the ones that will actually have the biggest impact going forward as we look at what decisions have impacts on many different issues. And this year, no exception. In fact, this year, really showing the first of the 6-3 conservative majority that is on the court that has been passed over the last few years with the additions of Kavanaugh, Amy Coney Barrett, Gorsuch, and others to the court, has solidified what is really a 6-3 governance of the cases coming forward. What does that actually mean? And I want to talk about it in terms of a few cases that are coming out right now and a couple of things that I want you to understand about what we are going through as a people when you understand how the court is looking at these cases. Now, there is and this is a loose interpretation of it, but it's a fairly accurate. When you look at the court's decisions over the years, you either have a group that is called more the originalists or constitutionalists that believe that the founding document, the Constitution, is the banner by which everything else is measured. It's the measuring stick. And if it's in the founding fathers enumerated rights that said this is what the federal government's going to do, and then they have plenty of rights that are interpreted or founded in the Constitution that may not be enumerated, but through tradition and through others, as Alito and others have said in the abortion decision recently. And we've seen it in the writings of Neil Gorsuch, Clarence Thomas, and others that are just, they're there and they're protected as we go forward. Now, they may be brought out of amendments, but they may be in the Constitution actual wording itself. And then you have rights, as the 10th Amendment of the Constitution says, that any rights that are not given to the federal government or named in the Constitution are then given to the states or the people. This is where we're seeing the interesting mix right now, because you have now a majority of the court that is constitutionalist or originalist in their intent. They frame everything by what the Constitution said or did not say. And then you have the grouping on the court and the political opinion that says that no, the Constitution is evolving, that you're supposed to use it as a measuring stick, but the measuring stick can be altered based on cases now and decisions of what's going on as we currently have it. This is what has formed the problem, if you would, or the crisis of many. And when you get decisions that have been handed out over the last few weeks, such as the Second Amendment decision out of New York, in which Clarence Thomas actually declared that, the Second Amendment could not be treated as a lesser right. What happened in the state of New York was they had a may issue condition on a carry permit or an owner's permit for a gun in New York State. What the reality was, you had to show just cause. Well, the just cause, as Clarence Thomas and others agreed on the court, was the just cause was you have the Second Amendment. The just cause says that you can own a firearm for your protection, that you can keep that firearm, and it's not up to the state to keep you from it for arbitrary reasons, such as a just cause provision, saying, well, do you really need it or not? That would be like saying that I needed, that if I don't have a specific amendment telling me that I need something, that I can't exercise it. What Clarence Thomas was saying was the Second Amendment guarantees that right of access to the firearm. And this is sort of one of the first cases in this past few weeks that sort of set off this version of what we're seeing in the 6-3 majority of the conservative justices, that the original language matters when it comes to deciding cases before it. Then we roll into the abortion case, Roe v. Wade. We'll talk about that a little bit here in just a little while. But we'll also talk about a prayer case that just came out of it. It was called Kennedy v. Bremerton School District. These two cases in particular sort of highlight the movement of this court from a sort of living, breathing, let's decide it as we feel at this moment cases with using the Constitution in the backdrop. But now the cases are being decided to say, no, we're going to look at what the Constitution says. We're going to decide, does that fit with our federalist system of government? Does it fit with the enumerated powers? Does it fit inside the Constitution itself? And if it does not, then we're going to reject it and send it back. Now, there's been a lot of criticism of the court over the last few weeks, and I've heard the hyperbole of many saying that the court is now, it is politicized. The court is illegitimate. It's interesting that the same people who are now saying it's illegitimate and politicized are the same ones that applauded decisions such as in Obamacare and decisions that have been made up until this point. And when it, again, the part of the problem that we're having in dealing with the courts is that people bring their political bent and bias to say that it should be decided by what I believe is right, not as against the standard of the Constitution. The courts were, I've actually heard it say, this is a Christian, a theocracy. We've heard all kinds of things over the past few weeks, but let me just put it very simply to you right now. That's not what the court's job is. The court's job is not to, in all fairness, from a conservative, liberal perspective, whichever way you want to bring this to it, it is to interpret the laws passed by the states or the federal government in light of what does the Constitution say. If it's not a constitutional issue, the courts are not going to deal with it, should not deal with it. If it is within the framework of what they can decide in the constitutional structure, then they are and should probably be taking more cases. These have to be understood, because if you don't take it as a look at law, a dispassionate look at what the law says, it goes back to a statement that I've made many times before, and that is that we vote in this country on words on paper, not ideas. Now, before you start to turn it off, or you start yelling at your in the air at the computer screen or wherever you are listening to this podcast, hear me clearly. You do have the ideas that come forward. We do pass ideas that are made in determining what we want to have. So, like, if we have this idea that we want to, form a government. We, what is the powers of our armed services? We want to have a new program that is designed to help with. Those are all ideas, yes. But at the end of the day, it's about words on paper. What do you actually vote on are the things that are actually subscribed down and written out to say, here's what and how we're going to go about doing it. That is all, frankly, that the courts should be looking at. They'll take into account precedent. They'll take into account past acts. They'll take into account, other ideas that have been put forward. But at the end of the day, they'll look at the law. They'll look at the decision before them, and they'll say, is this something that we say yes is constitutional? This is something as a proper role of government. This is something that our founders had set forth, saying this is what we believe this limited form of federal government ought to be a part of. Now, this is not going to make anybody happy, again, when you get a ruling that you don't like. And there's been, for many of us, we've had rulings that we don't like. Obamacare, Justice Roberts made it clear that the way Obamacare was continued, although many of us almost 10 years ago thought this was a very bad decision from the court, he based it under a tax code, which was not even argued by the Obama administration at that time. But they found the connection to the Commerce Clause, which then found its connection to the Constitution, which then, voila, found it as they say this is a reasonable act formulated by Congress. Now, I can politically disagree with that, and I can do everything I can to change that law. But what the Supreme Court said is, look, under the framework of what we see as the Constitution, this is a legal law that can be carried out. When it comes to the decisions surrounding First Amendment rights, Second Amendment rights, freedom of expression, freedom of speech, freedom of assembly, free establishment clause, the things that government are often around, this is when it gets to be more and more problematic to those who believe that the courts are there for political help, as opposed to the constitutional version of three branches of government, in which you have a president, you have an executive, you have a legislative, and you have a judicial branch. These are the areas of concern that have to be dealt with in court cases. So let's go back to this court case out of Kennedy v. Bremerton School District. This is about a prayer case. As a chaplain in the United States Air Force and as a pastor and others, I have dealt with these issues a lot. We have determined that there is this inseparable, many people in this country believe this is inseparable idea of church and state, that neither of the two shall meet. And the truth of the matter is that what the founders and framers says that there shall be no establishment of religion, and that the government cannot force or prescribe the methods of religion that are found in our country. In other words, you're free to worship and free to express that any way you can. It is not the government's job to establish one over the other. It's not the government's job to promote one over the other. In fact, the government's job is to protect your freedom of expression, your freedom of speech, as it comes forth in the rights dictated. And even if that means that if you are a government agency or you have people inside your agency who are expressing their freedom of speech and their freedom of expression, as long as that is not in a sense expressing that for the government itself, then you're okay. But this has been the problem. Nobody wants to deal with it. There's been this discussion back and forth, and we have the Gorsuch finally putting this to rest in this decision. And it's a 6-3 decision saying that this coach who is praying after a ball game on his own after the game was not at the time inviting others. He wasn't requiring anybody to pray with him. Of course, others would join him and gather him to pray. Was okay, because as Gorsuch says, Gorsuch said that the Supreme Court has made plain that there's no automatic establishment clause violation when a public school or other government entity fails to censor private religious speech. This is the interesting part of this, because what they're saying is now is the establishment clause is not the predominant view here of what we're dealing with when it comes to this. We're looking for the fact of how is this being expressed, who is being expressed, and do, as Gorsuch says, freedom of speech and the freedom of religion, this freedom, free exercise clause, and the establishment clause are all in the same sentence. In other words, he's saying they're complementary. They're not prohibitive of each other. And I think this is where I'm sharing that my excitement about this is you're finally doing away with a test called the Lemon test that was put into effect. And that the courts, in trying to decide if things could be, such as a creche or a manger scene being put up on public property, a prayer being offered at a graduation, these kind of things. The Lemon test from 1971 was developed to say, well, look, if you meet these, then we know that you can't do it. And this was a secular purpose. Does the purpose of the prayer or the religious activity have enhanced a secular purpose? Number two, is the primary effect to advance or inhibit religious expression? And number three, is it an excessive government entanglement? This is where the different factors of this one sentence come together. And there had been a move to more of an establishment point of view. Is there a government entanglement? Or this was the Sandra Day O'Connor version of this, that the establishment provision was one that would override this. So if it was within inside a governmental agency or governmental authority, then the establishment clause was sort of overriding, and in many cases overriding the free expression and the free exercise, free speech aspects of this clause. What Gorsuch is saying, we're doing away with that. Lemon test is gone, and the establishment, bias is gone as well. And they went into it, says, as Kennedy's prayers were private rather than government speech, Gorsuch said. Kennedy wasn't speaking pursuant to any official government policy or to convey a government-created message. The opinion said he wasn't instructing players, discussing strategy, or engaging in any other speech that the district paid him to produce as a coach. What matters is whether Mr. Kennedy offered his prayers while acting within the scope of his duties as a coach. And taken together, both the substance of Mr. Kennedy's speech and the circumstances surrounding it point to the conclusion that he did not. He goes on to say that we're replacing Lemon and its endorsement test with the instruction that the establishment clause be evaluated in light of historical practice and understanding. And in noticing this now puts us back to a constitutional understanding of this framework. It puts it back into a constitutional understanding of in the district case. In the end, Gorsuch wrote, he said, the district case hinges on the need to generate conflict between the individual's rights under free exercise and free speech clauses and its own establishment clause duties, and then develop some explanation as why one of these clauses in the First Amendment would trump the other two. But the district hasn't even shown that the clause are at odds. He goes on to say, the mere shadow of a conflict, false choice premised of a misconstruction of the establishment clause, and in no world may a government's entity concerned about phantom constitutional violations justify actual violations of an individual's First Amendment rights. In other words, what he is saying here, he said, is the establishment clause can't be always dependent on, that you have to look at the historical value, you have to look at the actual results, you have to look at, is it actually being promised and promulgated from a governmental position? If it is, then you're going to have a problem. If it's not, then you can't use that to trump the freedom of speech and the free exercise of those free speech exercise of a person's rights. In other words, that this coach had the ability, had the right through his own freedom of speech, his own freedom of exercise of that was apart from the fact that he was a coach in a government school. This is what many of us have been arguing for a long time. And this will have a dramatic effect, I believe, over a lot of parts of government, in where we have seen silly arguments such as a Bible being left on a military person's desk, or a prayer being offered in a non-coerced environment, others that may are in a school setting, or others. And we're going to see this actually now being evaluated a different way. I think this is a step forward. I think getting rid of the Lemon test, which was an arbitrary test that frankly doesn't address these issues of free speech and free exercise. This is a good ruling, and actually, again, protects. Now, I'm going to be very cautious here to tell those that from a Christian perspective, you are celebrating this, and you should be. But also at the same point, Gorsuch makes it very clear that free speech and free exercise here apply to anyone. So this is not just, and for those out there saying this is a Christian court implying Christian values, no, it's not. If this Coach Kennedy was not a Christian and he was praying prayers in another faith, a Muslim faith or a Buddhist faith or whatever faith he may prescribe to, what Gorsuch's decision is saying here, he says it's going to be okay. So this is why being very careful about these exercise of religion and exercise of speech, that it applies to all. You can't just simply say, I want my flavor of the month. I want what I believe to be protected and everybody else's to be out there. So again, I warn conservatives out there. I warn Christians out there. This is a good decision. It does allow what many of us have talked about from a speech perspective and an exercise perspective to be founded, especially when it's been conflated with establishment and government, promoting something that frankly that it has never been a part of. This is actually something that is very powerful when you start looking at the fact that the Constitution is now being upheld. It is not being let down. It's not being changed. It's not being subjugated. It's not being put into something else that it shouldn't be, but it is actually being put into the proper context that we have free speech, that we have free exercise. And that means for anyone and of any belief. This has been the argument that I'm anxious to see now how actually translates over into other cases. Now, there was a case that didn't actually make it, and that was a case that was challenging the defamation. That was the and libel prospects that did not make it. But it's going to be interesting to see later on is how this free speech is actually promulgated in other cases, which many people right now are dealing with social media platforms, and what people can say and what is getting censored. This is going to be interesting. Now, this dealt simply with the governmental and the establishment clause, the free expression, free speech part of that. But I think it will have overriding effects to understanding that free speech is especially outside of any contingent that would infringe upon it, is going to be upheld in this court. I think this is a good decision by the court. It's a decision that is now clarifying, especially doing away with the Lemon test, is doing away with many of the environments that have caused issues. Now, people are upset about this. We've seen people, already say, well, this is as I said earlier, a Christian court. This is, a theocracy that they're wanting. No, it's not. Take a breath, calm down, read the opinion, and understand that, frankly, what they're saying is that free speech and free exercise are something that is very valuable inside the Constitution. And just because they're in the same line with the establishment clause does not necessarily mean that you have given up your rights, especially if the government is not promoting, the government is not activating, and the government is not in any way establishing or promoting or taking a fair favor toward one religion over another. This is simply a complementary act that I think Gorsuch and the rest of the court actually did a very good job on. Now, another case that has been, and I'm going to finish with, we're going to finish up with this other case that's coming in. We've talked about the gun case, which again said, look, you can't infringe on the Second Amendment just because you don't want to. The second case being the freedom of speech, this exercise, this prayer case is coming up. But then we've also had the Mississippi, the Dobbs case that actually affected, and 5 of the justices said Roe and Casey need to be overturned. 6 agreed that Dobbs should be upheld, which meant that the 15-week ban on after 15-week ban on abortion in Mississippi was completely legal. Justice Roberts actually agreed with the court in this. And then you had 3 of the justices who said, no, we want to stick with this privacy found in our interpretation of what we believe the Constitution says instead of what the Constitution actually said. Now, when you look at the Roe progeny, the Casey progeny out of the Dobbs case, why was Dobbs decided? Why did the Dobbs case actually be a tool to go after the Roe v. Wade decision, the Casey decision? Many of you have asked, well, this should have been decided by itself. Well, it couldn't be decided by itself because the very essence of the Dobbs case coming out of Mississippi was this issue of viability, which first started in the Roe line of cases. When Roe v. Wade said that they determined the viability, that the states can not restrict under a certain age, 24 weeks, and others that they said then this violated the essence of Roe. So what started off as a discussion of can the states basically pass a law saying that past 15 weeks you cannot get an abortion. It triggered then the whole discussion of the abortion debate in general, how we got it from the Roe v. Wade case, the Casey case, as well, Planned Parenthood cases. These are now all been overturned. It now stands on the decision. Not only was Dobbs upheld, Mississippi can do what they want, but the bigger issue is now it goes back to the governmental bodies. It goes back to the states. This is actually, folks, the way it was supposed to be. If you understand our country and the founding fathers, a constitutional republic in which all views are looked at, that our country as a whole has a right to representation. It is not a pure democracy. In other words, 50 plus 1 doesn't win. That's not the way the founders set it up. That is a leading toward tyranny. This is a constitutional republic in which each state is represented by representatives who represent the interests of their state and their districts in Washington, whether it be in the Senate or in the House of Representatives. They represent those districts, and those districts are not going to be alike across the country. As someone who served in a body of 435 members from all across the country, it is a very understood fact that for some, that there are some districts in this country I could have never got elected in, just as probably the member who got elected in those districts could not actually have gotten elected in my district. This is the formation of who we are. What Roe v. Wade did, one of the problems that is that there are three basic problems that Roe had a lot of issues with. Number one, it took out and was undemocratic in the sense that it did not allow the decision, which if we get into it earlier, there's not a constitutional issue at stake here, that would have left it to the states to decide. Now, when you say, Doug, well, they said that there was these privacy rights and privacy issues. The problem with that is it was not founded in the enumerated rights. It was not implied by the founders of the Constitution. And there are other things in the Constitution that you can come back to say, here is the reason that we founded this case. Now, the issue is these problems that Roe had, and this was not just conservatives who thought this all along. The constitutional problem is this right of privacy was found in liberty in the due process clause of the 14th Amendment is broad enough to encompass a fundamental right to abortion. Again, they just found this. They made this up. They decided it was new legal principle, and there's no reason to think that it was true. Even professors who in law and constitutional scholars who have favored a right to abortion is found in state statutes and state law were frightened about Roe. In fact, a law school professor named John Hart Eli, who supported abortion, stated that this super protected right is not inferable from the language of the Constitution. The framers' thinking respecting the specific problem and issue, any general value derivable from those provisions they included, or the nation's governmental structure. It is bad because it is bad constitutional law, or rather because it's not constitutional law and gives almost no sense of obligation to try to be. In other words, what he's saying here is, and I've heard this a lot over the last few weeks, is that that you've taken away a constitutional right. No, this case did not take away a constitutional right. It was a court-given right. Let's define the terms here. It was a court-given right, not a constitutional right. It was a court-given right by saying we find something that's not in the Constitution, not in the enumerated rights, not even in something we could extrapolate from, but we're going to say it's there anyway. You just have to accept it. Even liberal legal scholars said, "Whoa, that's a problem. We may agree with what you're trying to do, but you're going about it the wrong way." As you look at this, the court was utterly committed to making this legal. We found that Roe, it was indefensible. Blackman opinion of Judge Blackman, who wrote the decision, and provided essentially no reason to support its holding. And the years since, Roe has come to basically be gutted from the inside out. it's interesting to note Rehnquist, who wrote the dissenting opinion in the Roe case, said that the court necessarily has had to find within the scope of the 14th Amendment a right that was apparently completely unknown to the drafters of the amendment itself. That's absurd. The only conclusion possible from this history, Rehnquist explained, is that the drafters did not intend to have the 14th Amendment withdraw from the states the power to legislate with respects to this matter. Again, let's clear up a few things here. Number one, this was unconstitutional. It's also undemocratic. It took it away. Roe v. Wade and the Doe voting cases took it away and from the states deciding on a non-constitutional issue and took it and said, no, we're going to just give this right to people and the states have to accept it. Remember, during this time, many states were already approving abortion rights. This was being decided at state legislatures and state assemblies all across the country. The proponents of abortion rights said, no, we don't like this. This is going too slow. We're going to take it to court. And that is what they did. And it also led to the almost 50 years of this case being now upended and undecided. It is also another part of this is just being unjust, that it basically says that the human embryo, the life that is inside the mother's womb, was not as valuable or protected as a life in any other stage. And this could lead to other problems in other stations, because I've actually heard it said, well, the human life inside the mother's womb, it doesn't, it can't defend for itself. It can't eat. It can't, it doesn't, breathe, or it doesn't talk. It doesn't communicate. Well, again, you got to be very careful there, because that also determines the areas of quality of life of others that may have been born, but maybe they're end of life. They don't exhibit these characteristics. Roe, it was very much of a discussion about whose convenience and whose priorities matter. In the life of the matter, in the life of the child inside the womb was determined to be less value of the mother and others. And this sets up a very disturbing scale when you start taking life and you start graduating it into deciding what's more valuable and what's not more valuable. All of these decided are the things that have made the Roe case so upsetting, and for so many. And I've heard this now that after this come out that Roe is now done away with all abortions. No, it hasn't. There's plenty of states in this country who have actually increased their access to abortion. There's going to be some states, though, that, however, after this decision, they're going to remove that right to abortion. Again, I can't emphasize this enough. This was part of the founders' vision. You have the 10th Amendment. You have those non-enumerated rights, non-found in the Constitution. Then they're not violated. Then they're reverted to the states and the people. This is where this is sent back to. So again, the idea that Roe being overturned does away with a constitutional right, number one, is fallacy. It was never a constitutional right. It was a court-given right. That's two different states of being there that you need to understand. It goes back to taking an original view of the Constitution, saying there are enumerated rights. There are rights that are found in the amendments, that there are rights that can be protected. And there are many that are not enumerated, but are found under the auspices of the Constitution itself. Alito, as he wrote about this, talked about those long historical rights of fairness and equality and others that are already there. This is what was trying to be said. He said, look, liberals and conservatives both agreed on one thing. Roe was very poorly designed. It was not a constitutional law issue. It was a personal preference issue of these justices to want to find or make up a right that was non-existent in the Constitution. Both conservatives and liberals agreed upon it. The difference is liberals liked it because it gave them access to a right that they didn't have before. Conservatives always said, look, this is a wrong right. If you want to do anything, it needs to go back to the states. So as we look over this over the past few weeks, and I wanted to spend just a little bit of time here on these court cases, it is not about an illegitimate court. It's not about a court that is a conservative theocracy bent that we have seen. It is not about a court that is fomenting for itself. It is a court that is actually interpreting the law. What is amazing to me, Alan Dershowitz, a famed constitutional lawyer, said this was judicial activism. I actually have to question this and say, how is it judicial activism to actually interpret the law in light of the Constitution, which is actually what the Supreme Court is supposed to do? And actually, if it means taking back and getting back to the original constitutional meaning, that's not judicial activism. That's actually saying we're doing what we're supposed to be doing, and that is interpreting by the Constitution, not enveloping it ourselves. Judicial activism inherently says that the judicial branch is legislating or determining for itself what the law should be, not interpreting it in light of the Constitution. So a lot of things been going on. I wanted to do this podcast just to clear up some issues that I see in this court. I've heard the arguments out there. Maybe we just need to take a step back, take some time, look at what these court cases actually did. And when you actually look at what they have accomplished, I believe they're putting the court on a solid legal foundation and a firm foundation to say, look, our Federalist Society still exists. We're a constitutional republic, and those things matter, and that the voices of the people actually have a voice. We just celebrated the 4th of July just recently. It goes back to the original documents that said, if from the will of the governed, from those, the consent of the governed. This goes back to the whole foundation of who our government is. This has been an amazing few weeks of looking and discussing, and I hope for anything that would take you, go back, read your Constitution, go back and read the cases from the Supreme Court that have come out of this. Understand your rights, understand enumerated rights, understand how our Constitution was founded to give us the states, to give us an executive branch, to give us a legislative branch, and a judicial branch. If this has done nothing else than to force us back to actually studying the basis of our democracy and to studying this constitutional republic, then these cases have done not only the job of correcting bad precedent and bad law, but they've now done the idea of getting us informed and getting people looking at what actually is going on in our country. And that is what we always try to do here on the Doug Collins Podcast. God bless you. We'll see you again soon. Hey, everybody. I just want to talk about sleep. You know why I want to talk about sleep? It's because I just got out from underneath my MyPillow bed sheets and my pillow that I keep under my head every night, because I like to sleep on my side. I like to sleep on my back. I like to sleep, I move at night, and MyPillow is just the best thing that goes under my head. It keeps me getting restful sleep. The sheets are amazing. It's just what you need. Everybody understands you need 7 hours of sleep. Why not sleep in some of the best products out there? And Mike and the folks at MyPillow are great folks to do this with. And you can go to mypillow.com, or you can call them at 800-564-8475. Use code word Collins, Collins. You won't want to miss this. If you have not got these Giza bed sheets, you need them. They're amazing. They're soft. They don't wear out. You need those to get that sleep against your body at night and provide that cooling, just soothing nature that lets you get the most sleep. But they're not just about bed sheets and pillows. They also have the My Slippers. Amazing. I've talked to you about it before. I don't wear slippers, but I do wear My Slippers. They're amazingly comfortable. You can wear them outside. You can wear them inside. Great products. You've got towels. You've got all kinds of stuff. Go to mypillow.com. It's spring cleaning time. It's springtime to get out there and try and buy new things. Replace some of your old stuff. You'll want to replace your towels. Get some other products for your bedroom. All at mypillow.com. mypillow.com, or call 800-564-8475. Use the promo code Collins, Collins. When you check out, I guarantee you will be satisfied.